Greetings. This is Professor Welch with the third recording in business law. This subject concerns contract law, which is a big part of business law, and uniform commercial code, which is a big part of business law. The uniform commercial code applies to transactions in goods. Transactions are often sales. Goods are anything tangible and movable, personal property, and not real property or services. So looking at a question, it says the statute of frauds refers to unfair contracts and makes them unenforceable. That would be false. The statute of frauds refers to certain unique subject matter that has to be in writing to be enforceable. If you don't have a writing or an exception, you have an unenforceable contract, which is like a homeless person with a toothless smile. It doesn't amount to very much. So those important subject matters are M, contracts in consideration of marriage, such as suppose the father-in-law is going to give the new couple a particular service or land or whatever if they get married. That would be contracts in consideration of marriage. And Y is contracts that by their terms cannot be performed within 1 year of the date of the making. L is land or interest in land. We need a writing because it could otherwise be easily frauded up. And then E is contract for services in excess, contract for goods in excess of $500. It specifically is not services. Contract for goods, anything tangible and movable, personal property in excess of $500 in terms of the price of that good. G is contracts to guarantee the debt of another. That's also called cosigner, or my students, I told them that was an idiot, that if you cosign on someone's debt and they don't pay, then the cosigner becomes liable. I remember in private practice, a couple came to me and said, we co-signed on a loan for my son to get a car. He didn't pay, so the bank has told me I have to pay. Aren't they foolish? I said, no, they are correct. You would have to pay. So guarantee the debt of another. You must have a writing or have an exception, such as they admit it in their pleadings. There is some memorandum or series of memorandums that document the transaction. In general, a contract must be supported by consideration, and that cannot be past consideration. Like I say, my secretary, I'll give you $500 for working for me 10 years. Well, that was consideration of the past. Illusory promises, it can't be illusory. That's where you promise nothing. I will order as many cherries as I choose. I promise nothing. Pre-existing duty, that's like a fireman saying, I will charge you $10,000 to put out a fire on your home. Well, he's under a pre-existing duty as a fireman, so that can't be consideration. So a contract starts out with an offer and then an acceptance, and then consideration is the plus element or the glue that holds the offer and acceptance together. And certain things can be consideration and certain things cannot. A contract for services is not covered and under the Uniform Commercial Code. It must be goods over $500. These are some of the basic terms that you need to know. An agreement for a 1-year lease to begin 1 month after the date the agreement made was executed must be in writing to be enforceable. And that they would need a writing because from the date of the making it's a year and a month or 13 months. So it has to be 12 months or less to fit with, I call that the Y, the contracts that by their terms cannot be performed within a year. Suppose someone says, because you named your son after me, I promise to pay you $1,000. Well, that's not a good promise because it's past consideration, and that's no good. It says if A contracts to build a house for B, well, that wouldn't be governed by the statute of frauds in terms of a service. That wouldn't be goods. There's a famous case in law school about Rose of Avalon. 2 farmers were out trying to buy this particular cow named Rose of Avalon, which is a strange name. And both of the farmers thought that she was sterile. So she was just worth a certain amount by the pound. And they made their agreement, signed it off and everything. But what they didn't know is Rose had a little trick up her sleeve and was pregnant. She was not a sterile cow. So that was a mistake that was mutual and basic to the subject matter. So the farmer who had this pregnant cow could undo the agreement based on mutual mistake. So that's different than a unilateral mistake where only one party's mistaken. I buy a home and I think I can resell it for $500,000 and I can't. Well, that's a unilateral mistake and that's not protected. Here's an example. If A hires B for $10,000 to bribe a juror and pays $500 in advance, the court will allow B to recover the balance. That's false. That's illegal. So if you want to bribe a jury, that's illegal and non-enforceable. Nominal damages are damages of $1. That just declares a winner. So if you win a verdict and you win nominal damages of $1, then that's just not very much. But if you have land or a unique subject matter such as some rare heirloom, you can get specific performance, meaning you can get an order and make them sell you the land. So when we look at liquidated damages, that's where the parties agree in advance that if there's a breach, this 500 or the 1,000 will be the damages. This often occurs like in real estate. They have liquidated damages clause. So if you don't go through with the transaction, then you'd have to pay the 500 or the 1,000. You can go into small claims court and indicate that this is punitive damages and try and get it back, but usually that's a hard one to win. Third-party beneficiaries. Sometimes you have the offeror, the one making the... we are going to conclude at this point.